IP, not just a fancy acronym for intellectual property, but a tool that can help set your business up for epic success. Welcome to the Fervent 4. Did you know that only 4% of businesses ever cross the annual $1 million revenue mark? Hello, I'm Zack Miller, author of Anomaly. And with me today, I have my co-host Tim Ryan, lead man at startwheel.org. Thanks for joining us. The Fervent 4 is a weekly show every Thursday at 11 a.m. dedicated to sharing insights into growing a world-class business, no matter the climate. The Fervent 4 is powered by the SBDC, which helps local small businesses grow through counseling and resources just like this show. If you're interested in learning more on how the SBDC can help your business, head to startwheel.org/weekly. Today, we talk about legal jargon, IP shop, and what you can do to protect your business. Steve duBois is an IP specialist with Patent Portfolio Builders Law. Welcome to the show, and thanks for tuning in. Hello, gentlemen.
Hey, Zach. Hey, Steve.
Hey, Tim. Hey, Zach. How are you?
Awesome.
Wonderful. What is like the most appropriate response to that, you think? Because a lot of people ask that question. Like, oh, how are you doing? Should you lie? Should you tell the truth? Should you say something chipper? Like, what do you think?
I mean, for me, it's just all how well I know the person. Yeah, I mean, or how much I think that they truly care or what their concern level would be. But
I think a lot of it's mood driven too. I mean, you want to be accurate and factual and not portray something that's not really going on with you. But, it's got to be mood driven to some extent.
Because most of the time people will say like positive things, even if their day is down in the dumps, if you really think about it.
Yeah, I know me personally, one thing that I learned along the way and was that I learned from feedback is that I would always talk about, man, I'm busy. I'm got so much stuff to do. And then people started taking that as I was too busy to talk to them, and I almost became unapproachable. So I had to really change that response because whoever I'm talking to, I want to make sure that they are the most important person that I'm talking to at the time.
Tim Ryan, the unapproachable.
Yeah.
Here today on the Fervent 4 show. So, Steve, you have an extensive knowledge base in the world of IP. How do you define IP? Because I think what's interesting about it is it's a word that maybe has even been glorified by Hollywood in the last 20 years or so, specifically probably with Facebook, and stealing ideas and things like that. Like, what does IP mean to you, and like what's the easiest way for someone to kind of comprehend what it is?
Right. Good question. So to me, IP means it's really a generic term for a number of different techniques that individuals and businesses can use to capture some of the value of their innovations. We use the word protect a lot when we talk about IP, to protect your innovations, and it does have that capacity. But really, in a broader sense, it's about capturing value and sharing that value within your organization, with your investors, to help leverage the business that you're trying to grow. So when I talk about intellectual property, I talk about how are you going to run your business, and how can intellectual property fit into your business plan to accomplish your goals.
Now, do you think IP is something that a very specific type of business needs? Is it like a high growth type of business? Is it a tech business? Does the local barbershop need something? Does the grocery shop need something? I mean, who should be listening? Who should be really looking at IP and thinking about it?
Right. Good question too. I think it's folks that are in businesses where innovation is occurring, or other businesses where you're investing in a brand. So those can be independent of one another, right? So if you're running a barber shop and you want to go national with some sort of a franchise because you've got a cool idea about how to run a barbershop business that hasn't really been done quite that way before, you may invest a lot of time, effort, and money in building that brand up, and you might want to protect that and capture that value. But you might not be really innovating in the sense of a tech innovation or something like that. So you have to break down this word intellectual property into sort of its component parts when you get into that kind of discussion.
Well, it's interesting too, because I think sometimes people don't look at their business in that kind of way, right? So if someone has lifestyled that business and said that's what that is, right? They've brick and mortared that business. And I don't think we're devaluing that business in any kind of way, but they're definitely different, right? And so if someone is just, I don't mean to pick on the barbershop of the world. I just got a haircut myself, right? You can't really tell, but I did, right? But there's nothing innovative in that necessarily. So then you're saying if in that case, that person doesn't need to get anything from an actual IP perspective?
Well, I think what I would say is that, again, when we talk about intellectual property, you got to be careful not to just hold onto that word and think that it means one thing, really, right? So intellectual property protects ideas. So people that are innovating and coming up with new ideas might be interested in one form of intellectual property. It protects and captures value in branding, which may or may not be terribly innovative in and of itself. But when you're tying the success of a good or a service to a symbol or an icon or a catchphrase, you may want to protect some of that value that you're capturing. And then thirdly, the third category we got to think about too is creative expression, works of art, novels, movies, things like that. Those can also be protected via another form of IP. So you got to break it down.
So IP really is a cornucopia of things, not just one simple thing.
How important is it to have the end in mind in terms of, that's something from a business side when I'm working with folks, it's like, even though you're just starting, you also have to have some idea, are you going to look for acquisition? Just having some sort of end goal to work towards from an IP standpoint, how important is that?
It's always good, I think, in almost every business process to try and understand where you want to end up, to plot out a roadmap on how to get there. And IP is no different, really. I mean, when I talk to people about intellectual property, I say, well, what is your business and what do you think intellectual property can do for you? And would you like to hear a little bit more about the different ways that I've seen people use intellectual property to further their business objectives? And it's really important, I think, to share that kind of information with whoever you're working with to develop an IP strategy.
And to follow up with that, so is it really, in terms of as employees come and go, is there some sort of documentation that you as the founder of your company or the leader of your company to keep on hand so that you can maintain possession of that IP?
Yes, we encourage companies that innovate. We talked about the three different sorts of types of IP a moment ago: capturing and protecting ideas, protecting branding, and possibly protecting the expression of those ideas in the context of artwork and novels. Particularly that first category, protecting ideas themselves and the implementations of those ideas. We encourage businesses to try and capture that data at the time of creation. A lot of larger companies use things that they call inventor disclosure forms, but really there are a lot of different ways that you can skin that cat to capture that information. But it is a tremendously good idea, regardless of how much you want to invest in actually protecting the intellectual property later on. Capturing it is always the first step. If you don't know what you have, how can you protect it?
So speaking of capturing, I know I'm going to butcher this, but at some point during the world, there was a way that you could mail yourself something, and that was all you needed from an IP perspective. But a couple years ago, that went away.
I'll tell you what, I've been doing this for 30 years. When I first got into this business, I heard that story. People would tell me that was a way to protect your IP. If that was ever true, it predates my lifespan in this
I've
business.
been lied to all this time.
Yeah,
come on.
It's a myth. It's a myth.
We need the Mythbusters on this.
Yep. No, that's not going to help you. You need to document your idea and decide whether to file with the patent office or the trademark office or the copyright office.
Define document in that case, or in like the earliest of stages.
Right. So there are formal requirements for certain types of intellectual property filings, but not for others. So the answer to that question starts to get a little complicated depending upon what types of filings you might want to do and how thorough you want to be in protecting your IP at the stage that you're at. It's a cost balance question, like a lot of other business decisions, and there are ways to do things in a more cost-effective basis that may not protect you as much as doing it in another way, but it may give you enough protection that you feel comfortable.
Yeah, I mean, so with that, you're a startup company, funds are limited, and how do you balance growing your business, acquiring customers, but also ensuring that you're protecting your IP? I mean, what's your recommendation for those startups?
Yeah, I think part of it starts with education, like a lot of other things. I don't expect my customers or clients to all become experts in intellectual property, although a few of them have over the years. But they ought to know a few of the basics so that they know when to start asking questions and when those decisions are actually upon them. For example, one of the things that has a tendency to erode intellectual property is public disclosure of the idea or the innovation. And so it's important for people to know and to understand that if they are going to decide to approach their customers to test market their innovations, what does that sort of public disclosure do to their ability to capture their intellectual property rights? So that's the time to have a discussion with someone like myself or someone who's knowledgeable in this area to sort of break down what is my risk if I disclose this publicly or start to do some test marketing, and what can I do to mitigate that risk, or should I mitigate that risk? So I think education is the starting point. Know the top 5 or 6 things that you need to know about intellectual property that start the discussion.
So as a marketing guy, I have a tendency to worry about startup, and maybe we should define startup too in this, but a startup spending so much money on legal fees to start when they haven't necessarily really figured out the business side of it. You've done the startup world yourself too, in the Bay Area. And so like, is there a percentage of legal related and IP related funds that you think a business in the early days should go towards something like this? Because it just seems like if they had 15% of their budget to go more towards marketing to try to get that to go, instead of protecting this thing that may or may not work, that's a hard pill to swallow, I think. And I get that all of them are important, but at some point there's a scale, I think, that says, okay, well, do you spend money on something that you haven't proven yet? But then when do you, if it is proven? And so it's kind of a hard
Yeah
scale.
really good point, Zach. And that's what it is. It's a scale. I mean, it depends a lot on the type of business that you're trying to start, how protectable the innovations that you're generating are. We look at things like how easy would it be to determine if someone is violating your intellectual property? Is it easy or is it hard? If it's really hard, like you've got some algorithm, some crazy algorithm that helps you navigate through Facebook, and no one would ever know whether your algorithm was being used or somebody else's algorithm, then that tends to devalue the intellectual property and make you consider to spend fewer resources on it. On the other hand, if it's easy to determine I've got intellectual property, that tends to increase the value of that intellectual property and make you want to consider to spend more resources on it. So there's a handful of 5 or 8 questions that we ask in that vein to try and help people navigate that difficult balance between allocating resources for other business functions and intellectual property.
On that same note, how does one judge whether or not they will have the funds to actually battle someone that might be infringing on their IP? Yeah. Because if I'm a small startup, I have 100,000 up to $1 million in revenue, and the person who's stolen my thing is, I don't know, Apple. Can you really compete with that?
Right. Right. Good question. I mean, another thing I tell people when they ask me that question is that if you get to that point, that's one of these good problems to have, right? You've got $100 million in revenue. You've got intellectual property that covers something that Apple stole or borrowed or copied or independently created and is marketing. Wow, that intellectual property just got incredibly much more valuable. So yeah, you've got a resource problem about how to unlock that value, but there are tools for that too. I mean, there are all sorts of bank-like companies that will invest in intellectual property monetization and that can help you leverage up to where even an Apple might be. There's always the prospect of going to Apple and just saying, hey, I'm sure you guys didn't steal my idea, but it seems like you're using it. Maybe you should pay me something for it so that we can resolve this amicably. So there's, like I say, that's a good problem set to have. I'll take that one every day.
Yeah, that's one of the things that so many companies, they always are so worried about is protection, and they have zero money. And at the same time, I'm telling them, if a company like Apple was to discover you, or any company that's doing several millions of dollars in revenue, it's a good thing to be noticed. It shows that you're on the right track. Really interesting point about being able that your IP goes up in value, in a situation like that. So that's a great takeaway for me. One thing that has shifted so much over the course of the past couple of months is everything has gone virtual. I mean, I feel like I live on Zoom. I live in front of the camera on my laptop. With that being said, now people, you don't necessarily know who is in your audience, and these broadcasts, they live on for years and years and years. How has that impacted IP, and how should people protect themselves from that standpoint?
Right. Another great question. I mean, a lot of that, the data that we're going to need to have to answer that question, because a lot of this virtual world that we live in now is relatively new. It's exploding anyway. Is yet to be seen. But let me just back up a second and answer the question that I think this sort of evolved from, which is I frequently hear individuals, startups, and even others say, I'm afraid that someone's going to steal my invention. This is just a common fear. They've put a lot of energy into it, and they want to know, what's the likelihood that's going to happen, and how can I protect myself against that? And I'll tell you, in my 30 plus years of working in this industry, I've never experienced an actual theft of an invention from one of my clients or customers, or even heard of one. Now, I have seen cases where companies and innovators were trying to solve the same problem at the same time, or roughly the same time, and independently arrived at similar solutions. That does happen. But actual flat out theft, I've never seen it. Should you worry about it? Maybe a little bit, but don't let it sort of stop you from following the innovation path that you're trying to follow.
So where did that notion of someone's going to steal my idea come from? Do you have the roots to that?
I think it's just a visceral human response. I've got something that I think is incredibly great. It's mine. I want to be able to do with it what I can do, and I don't want other people taking it. It's one of those things. It's like you don't leave the keys to your car out on the sidewalk because you're afraid someone will take your car. It's, as far as I can tell, that's it. Now, Tim did ask another part to that question, which is interesting, about the online aspect now of the gatherings that we're having, and the fact that you don't know who's actually looking at the material. And I will certainly agree that one of the ways to control your innovations and access to them is to know who's getting to look at them. And when in today's world, it's certainly the case that we have a little bit less control. So that fear is likely to increase, but I don't know that the risk really increases that much.
So a follow-up question to that, in terms of shifting topics a little bit to the NDA side of the house. The second part of the question with the businesses that I work with is, how do I protect my idea when I'm pitching something online? And the whole NDA aspect with investors. What's your viewpoint on that in terms of, yeah, I've never seen an investor sign an NDA.
They sure don't like to, right? Investors are paramount in risk reward balancing and risk mitigation. I mean, that's what they do for a living, right? So from their point of view, signing an NDA only increases their risk, right? Because it's essentially one-sided. You, the innovator, are giving me, the investor, confidential information, and I'm agreeing not to do certain things with that information. Otherwise, I face some sort of liability. So of course they don't want to sign them. What I usually advise people on this topic is to say, hey, look, Mr. Investor, as you know, public disclosure of innovations has a tendency to erode their value. And to the extent that you're considering an investment in my company, in my innovation, it's actually in your best interests to sign this NDA, because not signing it may hurt the IP that you might be investing in. So let's think about that for a little while before we just flat out say no to signing an NDA. And that usually at least starts a conversation.
So if you were an investor, you would sign an NDA?
Well, I'm not a professional investor, and I haven't studied the risk rewards there. But as an attorney, I'm happy to sign an NDA all day long, because my whole career is about protecting people's secrets. I'm not going to go out and disclose anything to anybody. Right.
I think is because the type of career that you're in, the kind of industry you're in, it's a little different. Because if that person, I mean, ultimately, I think this is, as someone who used to really be in that field a lot, I mean, I'll get a lot of people who would ask me to sign these things too. And I think to me, it was always, well, I'm not going to sign it, number one. But number two is, what happens 5 years from now when this one conversation when I had with here, now I've invested in this other company here.
Right.
I didn't invest in this guy because I just didn't think that they were the right team. The idea was fine, but they're the right team and a plethora of other things with a problem. Then 3 years later, 5 years later, I meet this other person. Everything's perfectly aligned, and I invest in that. But I signed this thing, so technically, I'm breaching of contract. I mean, when you see a lot of portfolios like this, when you see a lot of businesses in your portfolio like this, it doesn't make sense for an investor to go in there.
Understood. And I don't disagree with that. And I don't think my previous answer necessarily changes 9 out of 10 investors' minds about signing an NDA.
Sure.
But what it can do is start a conversation about, well, hey, can we take this in steps rather than me giving you the secret sauce of my whole business in pitch number one, where you're not going to sign an NDA? Maybe because you understand that publicly disclosing this to you without an NDA might damage the IP rights. Maybe you permit me to disclose only part of what what I need to tell you ultimately, not under NDA. And then if you really get interested and you need to know the special sauce, we have another conversation where we figure out a way to solve this problem. I mean, another way to solve the problem is to file for protection before you make the disclosure to the investor, right?
Yeah, I mean, not to mention most people who are hearing that conversation aren't going to understand the technical aspect of it anyway, right? And so you're going to have to, 1,000 songs in your pocket affect that, so that people can actually understand the technical. I mean, especially if it's a technical aspect of it, right?
Right.
That's
true.
Think about it. When Steve Jobs said that, I mean, it's not like MP3 players weren't popular. Apple wasn't that popular at that point. They weren't on an upswing at that point. They were selling crazy colored iMacs at that point. So the singular device wasn't doing it, but he said something that made it easy for people to understand. And I think that's what made the upswing of MP3 players become what they were. Were they MP3 players at the time? Yeah, I think they were. Who knows? That was so long ago. So when you were in, you good on that question? Do you want to say anything else on it?
No, I just want to say it introduces sort of the overlap between NDAs and filing for IP protection, to consider those things together, because where you might not be able to get an investor to sign an NDA, if you file, for example, a provisional patent before you make that disclosure, you have an alternative form of protection that protects you even if the investor won't sign the NDA, or at least gives you some protection.
Got it. When you were in San Francisco and you did your own startup, what was that around?
Well, actually, I was in California servicing startups like Apple, in fact, in the 90s. My startup was actually here on the East Coast. It was subsea fiber optic communications. We were building new optical fiber spans that were intended to traverse the Atlantic right before the internet crash because they were predicting all this need for bandwidth. And then that went away.
Well, sounds like, so why did it go away? Because it fixed it itself?
Well, when the internet crash occurred in 2001, the expectation that was
internet crash isn't like the .com crash or something different?
Yeah.
Mm-hmm.
Yeah. The expectation that there was going to be this projected need for a lot of extra internet bandwidth just went away. And so the need for hypersensitive, hyper creative technology in the optical communication space went with it.
It never rebooted though, as fiber was necessary later, or?
Well, it's like a lot of things where you have an anticipated need and startups get into the mix, and then that need just disappears overnight. Those startups, particularly if they were expensive to start up, have a tendency to be acquired cheaply by much larger companies. So they get their innovations for, a dime on a dollar, just because of the market forces that are, involved. So that technology did ultimately get used, but it got used by much larger corporations much later in the life cycle than the startups had expected.
What did you learn from that business that you used on an almost daily basis now?
I learned a lot about the thing that you said earlier, the business decisions that startups have to make about allocating resources and how difficult it can be to want to expend resources on legal matters. I mean, it's just not considered to be a mainline business topic like research and development for some companies, business development, things like that. So I'd say that hammered that point home for me, being on the inside. I'd heard it on the outside, but experiencing it on the inside was very telling.
Yeah, so it brings up an interesting thought, is that timing is so important when it comes to a business. Sometimes you time it right, sometimes you don't. So you have protection that's put in place, and then maybe you decide to either pivot or you just shutter your doors altogether, and then timing comes into play, and then the market comes to you. Yeah, how does your IP work once you decide to close, shut down the doors?
Great question. And of course, we're seeing a lot of pivoting these days, but it's not actually a new topic. One of the things I tell people about intellectual property is that one of its functions is to operate as a hedge against a failure to execute all or part of your business. I had a client in the early 2000s, which was trying to innovate in the space of providing you with a better interface for your television. Everyone was frustrated that with all the content out there, you had to navigate a linear system using up, down, left, right keys, and it could take you 15 minutes to type in the name of a movie you were looking for. So they came up with the idea that they were going to provide free space pointing, make it random access using an in-the-air pointer. But their main business was to sell the software, the interfaces for the televisions. They went into the marketplace, found out that the existing technology for motion control was not good enough for the user experience to be able to pick letters out on a television accurately enough to not frustrate them. So they invented their own suite of sensors that were way more accurate and performed that function in a lot better way. Turns out 5 years down the road, their attempt to penetrate the market with respect to the television interfaces was unsuccessful. The Comcasts of the world were not interested. They felt like they could do just fine on their own. But that motion control technology got picked up by Nintendo, and even now the big box TV manufacturers are using it, and it's showing up in robots. So they pivoted, and they had IP on both areas. And it's a good thing they did, because their sort of throw-in IP, this motion control stuff, was what turned out to be really valuable.
Interesting. So I have this great idea. It was too soon for the market, and then so I decided to shut my doors. But then a year later or 2 years later, someone has something that would infringe on the IP that I have. Since I closed my business, is it too late? And there's no leg for me to stand on, or is that something that I can go after the other company for?
Sure. Well, I guess it depends a little bit on how you close your business. A lot of these things close in the context of being sold somehow to somebody. And if somebody picks up your business, they're going to want to acquire the IP. So that's going to become their decision. If you shut the business yourself without selling it, but keep the IP alive, then of course you would have that opportunity to go back and try and monetize that IP, either yourself or in tandem with one of these monetization companies that could help you do it.
It's interesting. So I'm a big wrestling fan. Ridiculous statement of the year. It's June 18th. I'm 36 years old, and I still watch wrestling. Gosh, what a loser I am. No, well, maybe I am a loser for watching wrestling. I don't know. Okay, so back in the day, the WWE acquired the rights to one of their competitors called WCW, and the big thing, the reason why, is they wanted the video catalog, because they wanted to be able to replay that. It was before streaming and all that type of stuff. Mm-hmm. But they had this thought that in the future, maybe there would be this catalog of this digital catalog of all the pay-per-views, all of the normal TV shows that they had. And they acquired all that for actually very cheap. What's interesting is people now have talked about that. I think they bought it for like $2 million. And which is like one person's salary at that point in some of these cases. So what's interesting is they bought it for pennies on the dollar, basically, for that type of thing. I think it's very similar. So that would be like a copyright trademark. They bought the catalog, the IP. They're buying all that stuff because of that. Okay. So the Vince McMahon owns the XFL. The XFL just folded, bankruptcy, whatever the correct term is, but it's for sale. And so is it kind of the same case in that right now? Because I feel like we're kind of going through that where he's going to be selling the name and the rights and the IP associated with it, not necessarily the players, but the function of it. Is that what you would envision as happening?
Sure, absolutely. And a lot of times when I'm trying to explain intellectual property to virtually anyone, I use real property analogies. And you can envision intellectual property in this context just like the building that the WWC or XFL might have purchased for their offices as part of a bankruptcy proceeding or any other kind of transaction. You're going to try and sell whatever assets you have, whether they're tangible assets like a building or intellectual property assets like a brand or the copyrights to those videos you mentioned. So yeah, absolutely. I would foresee that that's exactly what's happening.
Very interesting. Tim?
Yeah, I mean, so as we're talking about all these pivots, how much of a pivot or how much of what you do as it evolves over time, how much of a change needs to take place before you have to say, we've changed enough that we have to take the next step to protect this IP? Or how much leeway does a business owner have? Does that make sense?
Yeah, so I think, pivots occur. The one that I described occurred sort of naturally, if you will. They can happen in a lot of different ways. I think what you try and do is set up some sort of a paradigm in your organization where you capture innovation in a way that allows people to look at it and sort of noodle over what its value is and whether it's worth protecting. And that can be in the form of because of a pivot, or it could be just a natural evolution of your ongoing R&D in your primary business area. I don't think that strategy really changes a whole lot. I think you might find, for example, that if you're in business A and decided that business A didn't really warrant a lot of intellectual property protection because of the type of business it was, but then you found yourself pivoting to business B, that you take a look at business B and don't rely upon your thoughts with respect to business A to make decisions about the intellectual property for B.
What's like the number one question that you get, or the frequently asked question that you get when you meet someone that's looking for IP related things or has a business and is looking to protect it? What are the frequently asked questions that you get over and over and over again?
Sure. So probably number one is, when do I need to think about protecting my IP? And I think that's referring to an earlier comment I made. I think that's an important thing for every business person, company leader, innovation output person to at least have a grasp of, because knowing the when starts the discussion about the how and the what's it going to cost in terms of resources and time. So that's probably number one question. I get a lot of questions about NDAs because a lot of people feel that NDAs are really all they need, and we have to have a discussion about what they're good for and what they're not good for. So that's fairly common too. Those are probably the top two questions, I guess, in this context.
Do you guys market towards that? So in Anomaly, the wonderful book that I wrote, all 54,000 words, I think that most businesses do a poor job of marketing their frequently asked questions. They don't get in front of them, even though they're the question that they answer the same way over and over and over and over again. Is that something that you guys have a tendency to push out as something like, hey, like if you're asking about NDAs, here's our answer on it. So then you can use that as kind of like a lead generator to then get new clients? Or how do you guys kind of intertwine the marketing aspect of those two questions into the day-to-day business?
Right. So I would say, if I was being honest, and I like to be honest, we have not done a great job of integrating some of those Q&As into some of our marketing materials. Because some of our marketing materials are directed towards larger corporations that have in-house advisors that are already fairly familiar with these topics. But where it does show up in our marketing materials is with respect to seminars, webinars, things like this, where we are directing, at least in part, some of the content that's being delivered. And these things serve as many functions. One is educational, but certainly one of them is marketing as well. And it naturally comes up either from someone like yourself as a moderator, or I may lead with it as a topic that I'll just bring to the table, or we might get a question from the audience that brings it up. But these things inevitably come up.
What's the number one fatal flaw that you see early stage businesses make? I mean, if you see over and over and over again that they fail to do that could have been avoidable.
There are some relatively inexpensive ways to protect ideas that can be leveraged that a lot of startup individuals and companies either aren't aware of, or they've heard some of these myths about them and they're afraid to look into them. I think not getting just a little teeny bit of advice early on before you do something like publicly disclose your inventions and erode their value is probably the number one mistake. I mean, I know that sometimes lawyers seem unapproachable, but just getting 15 minutes of a quick and dirty advice on where you are with your business and what you should be thinking about, I think is a good idea for most everybody.
Do you think they're unapproachable because people are worried about charging in 6-minute increments, things like that? Like, is it just like the history of hearing all these like terrible stories about how, when you sue someone, the lawyers are the ones who get rich, no one else in between? Like, I mean, the other story I was telling you about, you said it was never true. It was an old wives' tale, and so like. I mean, is it the same thing? Like, these things actually aren't that bad? You're hearing bad information from bad people and you haven't fact checked it yourself? Like,
I think that's a complicated question. It sounds simple, but I think there are a lot of reasons why attorneys in general and intellectual property attorneys, perhaps especially, are considered to be a little bit unapproachable. One reason, I think, is what you mentioned, that people are afraid of being charged money right out of the gate. And that's just, a function of the fact that lawyers historically charged by the hour, and people felt like when you would give them a ring that the meter would start running and they could expect a bill to show up the next day. And so I think it's in part incumbent upon myself and others who are in the community to sort of say, hey, look, there are other avenues for acquiring this information that are a little bit more approachable. I think another answer to that question is that lawyers are in the information business in large part. We're also in the experience business, being able to apply that information using our experiences to generate hopefully what's a good result in a business context. But when the internet came online, the mode of knowledge that we had the luxury of in the 80s and 90s, which we used to call something that I referred to fondly as a law library, went away. Anyone can do simple, basic legal research into intellectual property. And I think what that has done is to make some intellectual property lawyers try to make intellectual property a little bit more mysterious, because the mystique was taken away, in part.
So one thing that just popped into my head, I mean, so you're working with a new company. They have an awesome idea. I mean, this is something that is just just brilliant. You see the vision for it. Are there other law firms, or maybe have you worked with a company saying, hey, we're going to take you under our wing. We understand that you may not have money up front, but we're going to team with you, so to speak, to get you where you need to be, and then defer payment for later on down the road. Is that a strategy that some firms that you would use?
Yeah, that's something that we consider, and other firms do as well. And there are a lot of different ways you can package that. You can look at some sort of an equity stake in the company. You can look at deferred fees. You can look at a combination of those things. Any of those things are possible. Of course, the better the idea and the stronger the company, the less likely they are to wish to part with equity, which I completely get as a business person myself. But there are a number of ways that you can absolutely have a conversation with somebody like myself and see if that's an option.
Are there any good movies or podcasts or types of media that business owners should watch to really understand kind of the legal aspect or the negotiation aspect of what you were just talking about? So it made me think of the movie Negotiator as something in there. Or is there something that you think about when folks are thinking about kind of IP as, that's a good movie to think about from that perspective? Maybe it's Silicon Valley, the TV show. I don't know.
Yeah. So I'm not aware of any movies per se. There was a good book that came out maybe 5 or 8 years ago called Rembrandt's in the Attic. I'm certain there are a number of podcasts, and my marketing guy has been begging me to do one for about a year. And maybe this is the impetus I need to go ahead and get that finished. But I'm certain there are a lot of good resources for that. And I'll make a takeaway from that question to put a web page up, even if we don't put a podcast up anytime soon, to put up a web page with some links to resources like that.
So your marketing guy wants you to start a podcast or get on podcasts?
He would take pretty much anything at this point, but I think he'd prefer that I do both.
There you go. And you're against it?
Oh, I'm not against it. It's just time and resources like every other decision.
There you go.
Yeah, that's well, in terms of time and resources, one of the things that I am really thankful for from your standpoint is you understand the startup space really well. And even on our side down in the Hampton Roads area, Virginia, you volunteering some time and having open office hours to listen to startups, and where they can ask you these questions and not have to worry about the invoice coming in the mail the next day, kind of thing. So I really appreciate all that you've done, and you understand the space, and so I certainly want to thank you for that before we get carried away with the next conversation topic, and I don't get a chance to do that.
Well, you're quite welcome, Tim, and as you can tell, this is something that I'm both passionate about and just really enjoy. I mean, I get to not only do something I love, but I get to help people on doing it. What more can you ask for?
What's something that we haven't asked you that you thought we would have asked you?
You haven't asked me much about costs or specific IP related things that I could debunk. But I think you covered a lot of the things that I normally would get asked.
So let's talk cost then, right? As the world's greatest interview, that's me. I have to, figure out, how to get better at interviews, apparently, because I didn't ask you the questions that you thought you were going to. Now, so cost. I mean, what do you what do you think the costs are on something? Because you said there kind of three different parts to the world of IP. What are some kind of general costs and a highly generalizing piece on that?
Sure. Well, copyrights protect the expression of ideas. They're relatively cheap to obtain. In fact, most people can obtain them by themselves without much assistance by going to the copyright website and filing it themselves. The filing fee is nominal. Trademarks, which protect brands, are the next one up the scale in terms of costs. Typically, I would recommend someone to get some advice about filing a trademark, but it's not impossible to decode them yourself. Trademark filing will typically run you anywhere between $1,000 and $2,000 to get it started, depending upon how many classes of goods and services you need to protect. And then patents are probably the most expensive, but the thing to understand about patents is that they come in a lot of different flavors. You can file a provisional patent relatively cheaply for, say, under $1,000, or you can file a full-blown regular, what's called a utility patent that might cost you $8,000 to $10,000. And what you might need depends upon what you're trying to achieve. And that flows back into what we've talked about during this hour regarding the intersection between intellectual property and getting the shoe that fits you and your business, and not the shoe that doesn't fit you.
Right. So I did a copyright for Anomaly. I did it myself. And that was the one that you said is easy and you can do on your own?
Correct.
Yeah, well, there you go. If Zack Miller can do it, Caveman can do it. Anyone can do it. And I feel like, yeah, it was reasonable price. I think actually for the book it was less than $100. Yeah. And then it was, the thing that was great is, if I remember it correctly, I just basically copied and pasted the things that I'd already written already. Mm-hmm. And then I think you have to send them like a copy of the book or something like that, upload a copy of that. I'm sure, because it's 2020, things are a heck of a lot easier than they were way back when. But I mean, we should be appreciative of that stuff. I mean, imagine having to sit in line, to submit this stuff for days. I mean, that would suck. But now you just send them a file and call it a day.
It's so true. I mean, back when I started doing this, to file a patent application, to get a particular filing date, I would have to drive that patent application to the patent office in some cases and drop it off physically. Or I'd have to send it via express mail and hope the post office was open. Post office is closed. I'm driving to the patent office. So yeah, those days are gone. Thank goodness.
How about the timeline now from the time that you file to the time that everything is complete from a patent side? Is that sped up some? I know that was a big criticism that Mark Cuban would constantly talk about.
Yeah, they have provided some mechanisms for individuals and companies to expedite the system in individual cases. But the overall timing is probably only gone down a little bit if you look at the average time from filing to grant across the spectrum of all patents. But at least, companies and individuals, when they realize they've got a crown jewel that they need to get out of the system more quickly, there are tools to do that now that didn't exist 5 years ago.
Are you a fan of the show Shark Tank? Have you watched the show Shark Tank?
Yeah, I love Shark Tank.
Is there any, I think it's really helped, at least back in the 2010 or early 2010s, to really accelerate the growth of people wanting to start a business. Is there something in there from a myth that you've heard a shark say, or something that the show has said that was really made you go, ugh?
Well, occasionally they'll use generalizations like, anybody else that's generally familiar with a lot of topics. Some of those folks that are evaluating inventions and business propositions will say things like, you're not going to be able to protect that. Someone's going to steal that. Or, just very general conclusory types of things that relate to intellectual property, which normally I'll say, wait a second, let's just take half a step back. That may not be true. But other than that, no, I find it to be, a really good combination of business-related activities, legal activities, financial considerations. It brings it all together. And we talk about accessibility. It makes this whole topic, in some ways, a lot more accessible to people, I think.
Yeah, it's been
No, so with that, one of the big things that we hear on Shark Tank all the time is outsourcing stuff to China. Is that really that big of a nightmare, is what everyone says in terms of protection? What's the truth behind that?
That's a good question too. There's a lot of concern over that. The IP filings in China have gone through the roof. So if you just look at the fact who's filing for patents in China and how many are being filed, it's clearly the case that a lot of people and companies believe that there's some way to protect your innovations in China. Otherwise, they wouldn't do that if it was a complete falsehood. And there are reported cases over there of some international companies winning patent disputes against Chinese companies. They're still largely in the minority, so it's still a big concern. I think largely when you hear in the news today about intellectual property being stolen by China, a lot of that is research material and innovation from universities and things of that nature. It's not typically manufacturing related, to my knowledge.
Yeah, I actually have some clients who manufactured in China and have great relationships with those individuals, those businesses there. And then they actually like to partner with them to have some sort of specific country rights to send stuff out, is how I can think of how that went with this specific business I'm thinking of, which would contradict what most people are hearing in the world rather than what you just said too. And then what this other company has seen. Obviously, it's a very small case study, but it's always interesting to hear like, okay, what did the media tell you in that case? And then like, what is actually happening in some of these cases? So
yeah, it's a very interesting question, because with all the publicity that this topic's been getting recently, I've thought to myself, and since my marketing director's been challenging me to do podcasts, I like to challenge him occasionally to do things. And I said, look, if there's really a problem with intellectual property in China, why don't you find some of these problems and maybe we'll sort some of them out, and just look at it from that perspective. And it's not quite so obvious outside of the research area that I mentioned what these problems are, or how tangible they are.
But they're very clickbaity.
Yeah.
And someone saw it, now they believe it, and now they have these assumptions instead of the yep. Yep. I don't want to go on that tangent. I'm good.
Yeah. I mean, how does that work from from outsourcing code development for apps and whatnot to India or other places like that? Is can you protect the code? I mean, they're building it, they have all the source code. How do you protect yourself from that standpoint?
Well, we've been in the business of doing joint development agreements and things of that nature for a long time. Even before there was outsourcing to India and China, in the United States, companies and individuals would collaborate on projects where someone would bring a certain piece of expertise to the table that the other set of people didn't have. And so, for years and years, we've been drafting what's called joint development agreements, JDAs, which outline the different responsibilities of each of the parties, what they're going to contribute, and then who's going to own the rights to those things. And you can divide that up pretty much however you'd like to. If I'm putting all the money into the project, but I need somebody to write the code, whether it be here in the US or outside the US, I'm probably going to want to own all those rights, and that's going to be in the contract.
Can you blame them?
No.
Yeah, that's interesting. That's that would be my one takeaway from today's show. I had not heard of that type of an agreement before, a JDA.
Yep. Also, copyright law makes a provision that's called work for hire, which also would be applicable under these circumstances where somebody's writing code for you. You would essentially automatically inherit the rights to that if it's a work for hire, if it qualifies for that.
Love it. Steve, anything that we have missed that we need to touch about before we wrap?
No, I think you guys have done a great job peppering me with the appropriate questions, and hopefully I've given you some good answers. Really appreciate the time today, and be happy to speak on this topic again at some point.
Got it. For those of you guys listening now and later, make sure to check the team out at Patent Portfolio Builders at ppblaw.com. That sounds like a tongue twister. Can you say that 3 times fast?
Don't make me.
Don't make you. All right, we won't. Tim, any last thoughts?
No, I think that I was in learning mode for a lot of this, so I appreciate all the knowledge that you dropped upon us, Steve. It was appreciate it.
Well, I'm also glad to have given you a first in that I managed to interrupt the podcast for my lawn guys trying to fire up the lawnmower. And so I'm going to, sign off here in a minute or two and go tell them that they can do what they need to do.
Have they just been sitting there for an hour?
No, it's a neighborhood set of folks.
Okay.
So they just went to their next project down the way.
That would have been better if they were just sitting there waiting, like, come on, man, it's hot outside. I mean, my major takeaway would be like, don't just assume anything. And that's not just with legal, but don't assume things, right? Figure out who the expert is and ask them questions. A lot of them won't provide you with the things that you had heard in the past that were negative, right? And so by just creating a relationship with you or someone on your team, I think it would be a great opportunity for someone to enhance and see where that can go next, instead of just saying, no, I'm not going to do that because someone in the past told me this. What happens when you just, you hashtag just say, hey, a lot can happen. And so I think that's very powerful.
Yeah, the other comment I'd add to that too is, to the extent that you find your local intellectual property lawyer a little unapproachable, there are people like Tim out there with startwheel.org who, they know the different people in the different areas, not just intellectual property, but, financing, business organization, whatever it might be. They know the folks that are going to be more approachable and who are the right people to plug in. So, leverage the community.
Love it. Always leverage the community. Check out Tim and Startwheel at startwheel.org and go to ppblaw.com for patent portfolio builders. Appreciate you guys listening. Until next Thursday, we will be just trying to figure out our IP game because now I have like 60 minutes of content to rewatch over and over again to figure out if I'm doing all this right or wrong, which, I guess we'll find out next time. So appreciate your time, Steve. Tim, always good to see you. Until next time, y'all. Peace.
Take care, Steve. Thanks, Zack.
Thank you. Thank you, guys.
And pancakes.